but I was very excited to see the topic that we're looking at post-COVID-19 and how the legal side can support the businesses when this pandemic is over, which will eventually be. Just to introduce myself, I'm an attorney. I was qualified 15 years ago, and majority of my career has been supporting businesses from operational perspective, internally and hands-on inside a business. So for me, my true passion is to assist businesses operationally and see how legal can support the business and not become a hindrance for their businesses, and to see how it's more a step to do your legal compliance side. Firstly, I have created a slideshow, and I'll take you through the topics that we're going to discuss today. Firstly, I just want to mention that the session is very informal, and I'm not looking at the technical legal aspects. I'm more focusing on the operational side and how business can assist with the compliance and moving forward. And please don't take everything as a legal advice at this stage. You're more than welcome after the discussion to get more specific legal advice on a particular matter. The topics that we're going to discuss today is the legal and operation side, resolving disputes, and risk mitigation. On the legal and operations, as mentioned, the legal aspects can support a business tremendously when you have your basic legal items to address. And I always tell my clients to start off with a legal audit. I find it very helpful, especially in this time, when you have time to have a look at all the documentation that you currently have in your business. There might be documentation that no longer speaks to your future strategy and also your efficiency that you're looking at increasing in your business. The processes, your documentation, and your business strategy all has to talk to one another. And it's a very good time now to have a legal health check on your business and do a little small audit to see on the documentation that you're currently using that you're still on par. All documentation, and I've met so many clients currently in this time, especially, that don't have signed contracts, and that complicates your legal position and mitigation of your risk to your business if you don't have a signed contract. Legal enforceable contracts to be in place, and that speaks to your operation side of your business. Everybody now is looking at efficiency in their business on the operational side and how they can better their business and save costs. So it's a very important question now to ask is the way your business is concluding contracts still relevant to this time? And how do you foresee changing the way you contract with your customers or with your suppliers in the way going forward? Days are gone where you do your contracts in a paper form and you print your paper and your customer signs it and you store that in a file in the office. There's so many exciting opportunities for businesses to contract tech on your electronic formats, and with the law today, there's benefits that you can still tick the legal compliance side on your contracts, even though you don't do the traditional printing of a document and signing it. So if your business is moving forward and you're looking at your new strategy and your efficiency, it might be that you decide that your business and your distribution model that you're currently running is not the way the future is. And for your business to be more efficient, your sales team might need to want to contract with your customers differently than it's currently being attended to. If you look at your contracts that's still being, whether it's still relevant, you can move the way you contract to a different platform, but you have to ensure that how you contract is still legally enforceable. And this is where electronic contracting and a paperless environment is a huge benefit going forward. In terms of South African law, you are entitled, or you can conclude your contracts electronically, and your contract will still be legally enforceable. If you have time, as I mentioned, I'm not going to quote legal terms and acts, but Electronic Communications and Transactions Act of 2002 gives you the opportunity to transact with your contracts electronically. And I'm sure you all know that there's a few ways that you can contract electronically. If you go online and you purchase an item or goods, you would, by ticking a box, accept the terms and conditions of that the person selling the goods online. So in terms of our act, you would typically conclude contracts either way by electronically accepting it, as I mentioned, by ticking a box, which is legally recognized, or data messages on email that's transacted between two parties, or you can attach a electronically encrypted signature on your contracts, and that by that way you can really move towards a more efficient and a different distribution model on signing your contracts electronically. When your contracts are concluded electronically, you can have a look at the storage of these documents, which we'll get to later on, the retention obligations. But legal electronic communication is now the way to go. So for you to conclude your contracts, just be wary that there's certain instances where you can amend a contract on a data message between two parties, where the intention might have been that you don't want to cancel a contract, and you do so on an email. So it's very important, if you want to move towards an e-commerce basis and you want to conclude now your contracts electronically, to still be very wary of the legal implications of doing so. Electronic contracts you can do on the e-commerce side, and besides your electronic contract that you accept by ticking a box, there are other legal obligations also when you move towards your new distributing on a website and selling your products now online. For example, when you do your online business model, you would, besides the contract that you conclude and your T's and C's that you accept electronically, you have to have your data privacy policies in place. You need to make sure that you've got terms and conditions, and also use of website terms and conditions, in order to mitigate your risk and to be legal compliant on that basis. So when we all move to a more efficient distribution, and we have electronic communication, and we contract our contractors electronically, we no longer have the issues of paper, which is an excellent way of making your business more efficient and moving away the traditional way of concluding contracts and saving it somewhere and storing it in your offices. In South Africa, you can make use of the retention of certain documents and apply the laws to see what your obligation is in storing these documentation. There are various legislation that you can apply. So if we look at the document retention obligations, there's a few pointers that I'd like to just give you guidance on. So firstly, you might have an office that's full of documents, and you want to move now towards a more efficient way of accessing your contracts or your paperwork. You can consider the type of documents that you have in your business, look at the laws that apply to that contract or that document, and then see what the law provides for you and how do you need to retain these documents going forward and to comply with the legal side. There is fines if you don't keep documentation for a certain period of time, and obviously you want to avoid that. So for example, if you look at your different departments, you might have a finance department that keeps credit notes and tax documents and invoices, and you might have an HR department that has different documentation from an HR perspective. So those documents you need to retain for a certain period, and you can destroy that after a certain period. The law also allows for you to retain a copy of a document and no longer original, or where there is an original requirement, you can keep the original document, and also maybe just use software where you can encrypt the document, which will then be certified as an original document that you can keep online and store in the cloud or wherever you've got your secure to access to. So just 3 points to summarize on the retention obligations is: look at the type of document that you're sitting with in your business, whether you want to keep the original or the copy, what the law requires. And if you don't no longer require the document to be kept as an original, you can destroy the document, which is a great way of cleaning out and no longer having to pay for storage offices and keeping documents for a period that's no longer necessary. On the legal and operations side, when everybody is now looking at the operational efficiencies in their business post-COVID and how they can make their businesses more efficient, I always look at the 4 core relationships of your business. The one would be your management. You might have now a situation where you've got investors needing to give extra funding in your business, and that might have an impact on your shareholding or the business structure. Always have a look at your shareholding agreement and see how this is going to affect your post-COVID and if there's any changes that you require there. On the employment side, you might have staff that's now on a different view of working, and you might say that you can see that your operating expenses are less now with staff working remotely, and you might want to change your structure on your employment side. So for that relationship, you always have to look at your employment contracts that you've got in place, and also obviously the applicable law that would govern if you need to make any changes to your structures. On the supplier and distribution, as mentioned earlier, you might need to re-look at your distribution model. You might think that e-commerce is now a better way of and more cost-effective way of distributing your products and services, and always look at the contract and revisit the terms post-COVID and how you want to engage with your supplier going forward. On the customer side, we touched on the way we contract with our customers and moving to a new way of connecting with customers and no longer having a long process of signing up customers and signing T's and C's and application forms, which can now all be done electronically. On the COVID side, during this pandemic, dispute resolutions has become such a tremendous aspect, and it's so important to focus on a more efficient way of resolving disputes. Firstly, I want to encourage you to have a look at your contracts and see how that caters for a dispute, even now and after post-COVID. And disputes should always start with finding a way of mediating and finding a solution that's the most cost-effective to your business and that is not that time-consuming. Your traditional dispute resolution processes are usually entailed in your contract, and currently we deal with a lot of force majeure disputes, and many times there's no contract in place. So if the one thing that you can learn from the COVID experience is just ensure that you have your compliance and on your legal side, and that you can have a reference to a legal contract when there is a dispute that is being faced between you and another party. Traditionally, your contracts have an arbitration clause that is an efficient way of resolving disputes if there is any matter that cannot be resolved. Typically it would entail 2 representatives of a party that would sit and try and resolve, and if it doesn't, it would move over to a more formal arbitration process. You would have seen AFSA, one of the arbitration forum that you can use. arbitration is still a more efficient way than approaching a court. I mean, I think the back roll now is about 2 years to see a matter through. And even though your court process, you only pay for an attorney or an advocate, that's still for free to approach a court, but your time frame and the time that it's going to take for you to resolve the dispute, for me, in my view, it's not feasible. So the arbitration process is a more effective way, but it would be more costly, as you would need to rent venues and get an arbitrator appointed, which can be more expensive. The one aspect that I'm very passionate about is the commercial mediation, and that's a very informal process where parties get an independent mediator, a commercial mediator that can sit with parties and discuss a matter and see maybe if there's an independent view on a dispute, the person might be able to get guidance on that. So just to get back on the force majeure disputes, and currently everybody is in a situation where they're looking at their contracts and phoning up and asking whether a force majeure event is now the trigger of cancelling their contracts. And it's very important to not just call force majeure for any contract where you can't perform. It's very important. So force majeure basically means that in a situation without it's not within your control, and you can't carry your obligations, so you can't perform for reasons it's not your fault. So firstly, if you have a force majeure, if you have a contract in place, you will look at your force majeure provisions, and that would usually define what a force majeure is and which instances a party can call on a force majeure to suspend their obligations. Where there is no contract in place, and that is where the difficulty comes in, where parties are not able to amicably be and sit around the table and resolve it in good faith, you're going to have to rely on the common law provision, and that is sometimes more tricky when you have a dispute on whether the force majeure is really applicable and whether the party is not only just trying to avoid their obligations in terms of the contract. When you do call for a force majeure and you implement that and it was not justified, then you do face the risk of being found in breach of the contract. And that is not something that you obviously want to avoid that. So firstly, on the force majeure, try and have a look at what your contract says and what is defined as a force majeure event. And if it does provide for you to suspend your contract, always keep the other party up to date. And I really impress on that, to keep your situation and to notify your other contracting party what the situation is. I like the comment that Catherine made the other day about respect and how people treat each other during this time. And for me, it's a very good indication if you can sit around the table and try and resolve a current situation where nobody is at fault. You can face your supplier and your employee after this. And I've seen many instances where people are able to sit around and work around the force majeure situation. And post-COVID, I'm sure that relationship will just build further. So from a contract perspective, going forward, make sure that your dispute resolution clauses are in there, and you can even provide for a mediation process in your contracts. So mediation, I always say, don't litigate. I'm a very big advocate for mediation, and it's a more informal process. The one thing that you need to know about mediation is that it's not a binding process. So whatever the outcome is, it's not binding. You would sign a separate settlement agreement just to enforce being able to enforce whatever was agreed to in the commercial mediation process. But I've seen many successful dispute resolutions, and it's not as expensive as your arbitration process, and it's more informal. It's a very good process where you get a third party that's not emotionally involved that can assist with this dispute resolution. You can insert a clause in your contracts that deals with commercial mediation. If it doesn't, if the dispute's not resolved by commercial mediation, you can then follow the arbitration process and try and resolve it in that way. Just note that if you do have an arbitration clause in your contract, say for instances where you need to approach a court for urgent relief, you have to follow your arbitration process first before you can approach a court and issue a summons and resolve it through the court process. The next topic is risk mitigation. And this is an extremely important element that you have to keep in mind post-COVID. And during the COVID period, we learn. Businesses I see now think of things differently. They see the operations differently. They've learned now from what risk can be faced and how do we deal with it going forward. I remember many years ago when clients, the biggest risk was for the building to burn down, and to ensure that your server is that you've got access to all your documents on an independent property where their server is stored. So for risk now is different, and there's different ways of looking at your risks. And from a legal perspective, I've covered the policies, the company policies, and your IT system and security policies that you can update. Now, there's many policies that's floating around that you can use, and it's such a good time to have a review of your company and your employment policies. Would you have your employment contract that would govern your relationship with your employees, but then separate from that, you would have all your company policies and your employment policies, what the employee has to comply with. These policies you always keep separately from your employment contract, because your policies you can update and share with your staff as you change them. And your employment contract, you obviously can't change it unilaterally from one side. So that's why it's very important always to keep your company policies separate from your employment contract. On the employment policies, you can have a look at updating your disciplinary processes. There's many new creative ways of holding disciplinaries during this time where all your staff is working remotely. And unfortunately, the employment elements and the issues it's not less. So even while you have a staff member now that's working remotely, you can still proceed with disciplinary hearings, and you've now got access to your staff whilst they're at home working remotely. And your employment policies, you can update your disciplinary to ensure that you cover disciplinaries that may take place via Zoom and remote access, and no longer the traditional disciplinary where people sit in an office and a chairman is there. You can update your employment policy by introducing a notification via WhatsApp. So you might want to give your employee formal notice of attending any hearings by different ways of notification. And very important now is a remote working policy. So staff members now get the opportunity to work remotely, and with some people you can leave and keep them to their KPIs and they still perform. But other staff, you might want to put in more strict ways of measuring your staff. They might need to look at amending their KPIs and how you're going to measure their work output. For me, working remotely is one of the best and the positives from COVID. And I think a lot of companies are going to moving towards a company policy where you work completely remotely, and that side will definitely see some changes. On your IT and your security policies, obviously now your staff members are working remotely, and you don't have access to see where the offices are set up at home. Always ensure that your confidentiality of your documentation and your company information is still secure and people still respect the confidentiality around that. You don't want staff people keeping documentation that's confidential lying all over the house and people having access to it. So from an IT and a security policy, there's a few items that you can update and ensure that your staff have access on a secure network. And also when IT equipment from companies are used at home, how do you deal with your insurance on that? And if the staff member loses the laptop or damages it, and the kids are not all working on the laptop, how are you mitigating your risk on that side? So from a risk mitigation perspective, it's well worth to have a look at your company policies, your employment policies, and your IT and security policies to make sure that it's talking and it's addressing the legal aspects going forward, and having a bit of an open-minded to see that the traditional risks that our businesses face has now changed, and we have to adapt to that. And going forward, there's a really very good advantages of putting those policies and updating them. So in short, the conclusion now is the legal processes that you have in your business, legal can add so much and tremendous value of bringing efficiency in your business, updating your policies, and also your efficiency in your business. See how legal can support that and how you can still be legally compliant and your businesses can still, with new distribution models, you can still do all the legal ticks and the legal compliance on it. Get your business updated, get your contracts, get your audit done, have a look at your contracts. Does it speak to your business and your relationships with your suppliers, with your customers, and see how the new business and the new efficiency is going to address growth in your company going forward. It's such an exciting time to see how legal can work with businesses and post-COVID still see a lot of success and keep your business still legally compliant. So that is from me, a short and sweet. I don't know, Mary, if there's any questions.
Hi, Danelle. Yes, there are a few questions. I'd like to just firstly ask Ruan. He sent a private question, but he's willing to ask it to the forum. So I'm just going to unmute him. Okay, Ruan, feel free to ask your question.
Hi, everyone. My question is just, I have a office assistant that helps me and the other director with some office work and also running the company. Do we need to set up a contract for her as she's not an official employee of the company?
I would recommend, Ruan, thanks for the question. It's important to have, are you employing her just as a temp now, or what is the arrangement?
So it just helps us on a temporary basis, so to say, but we don't give her official pay or anything. So she gets, whenever we have a big event, we give her a percentage of the profit that we make.
Okay, so is she only doing your admin, or is she involved in the sales as well?
No, just the admin side.
Okay. Well, you know, I would recommend that you put a contract in place, even if it's a short duration, a fixed term contract. It's always good to just regulate the relationship. You don't want to create an expectation with her that she might get a full-time employment and you know, you want to always tick the legal on the employment side. So my recommendation would definitely to get a fixed term contract in place with her, even if it's for a month or 2 months, and set out the relationship and what the expectation is. If she does get a commission for, as you say, regulate that into a contract. If she works the certain hours, you obviously know that there's a UAF obligation if there is any payment. So just check on that you do tick the labor aspects. But just to answer your question, I would definitely put in place a fixed term arrangement for a certain period.
Cool, will do. Thank you.
Thanks so much, Ruan. Then we've got another question from Nick Majima. Would you like to ask your question, Nick?
Okay, I think the question is on most of the e-commerce sites, you find that you do have terms and conditions that you put in, and if you are going to ship internationally, there's always the issue of jurisdictions whereby customers are asking, is this going to apply if I'm in the UK or if I'm in Nigeria? How does it going to work? How do you foolproof your terms and conditions so that you don't get found wanting in terms of jurisdictions and which jurisdiction is supposed to apply?
Yes, thank you. So your terms and conditions, your company now registered in South Africa, you're free to choose which governing law is going to regulate the contract that you put on your e-commerce site. So it would be a standard practice for you in your T's and C's to select the governing law that governs your contract, and you can make that South Africa. And if there's any dispute, you can also select which jurisdiction would have which court would have jurisdiction over that dispute. So that is free for you to put in your contract, your T's and C's on your e-commerce site.
Okay.
Does that answer your question?
Yes, it does. I mean, we just have been having up and down with clients to say before they pay me, they do payments and say what guarantees do they have and what jurisdiction is this going to apply. So it's really a question to say, how do you make sure that it kind of accommodates them so that it doesn't exactly disadvantage them and scare them away? I thought maybe there is a mid ground that you can find to not to scare them, to say if they are in the UK and they want to do payment and the jurisdiction is South Africa. I know most of the laws are kind of similar, but to say if there's a dispute resolution and it has to be resolved in South Africa, it means a cost on them, and some of the clients are not exactly willing to take care of that and say who's going to take care of the cost of them coming to South Africa to do the to attending all the sessions.
Yeah, but just also remember, I mean, from your perspective, you would want to choose the law that you want to apply. So, say for example, there is a dispute on payment, you would want to apply the law that's in your favor, and it's going to be less costing for you to enforce your rights. So you're more than welcome to engage with me afterwards if you want to show me your current T's and C's, the terms, and your governing law and dispute resolution provisions that we can see. But as I say, you can choose which jurisdiction you want to apply in your contract.
Sure, thanks. I think I will engage you afterwards.
Yeah, sure.
Thanks so much for the question, Nick. I'll introduce you to Danelle over email. Then just two questions that came through to me privately. The first one, Danelle, was if businesses are able to trade according to the government under our current lockdown stage 4, but they're renting a space from a municipal building, but the municipality aren't allowing them to trade. Now, obviously, this is a huge concern. Is this legal to enforce this?
So are you saying that the municipality is not affording access?
Yes, they're not allowing the business access to their rental space within that municipal building.
Yeah, so for me, from outset, I mean, it doesn't sound right. So if you've got a lease in place and you're entitled to trade, you obviously, in terms of the regulations, you essential services or whatever, you must be able to access the premises. So from a landlord perspective, they must be able to give you access. I'm not sure what the exact reason is for aren't allowing them to trade from the premises.
Yeah, I think what I'll do is I'll also just follow it up privately, and we can also understand, because obviously with a permit, they shouldn't be able to deny if they've got an essential services permit for the stage.
And I know from this week, premises are open for, if your business is open to trade, you should be able to have access to your premises that you're renting from.
Yeah.
That
Exactly.
we maybe look at it separately.
And this is quite a specific question, again, just received privately. I have an employee going on maternity leave from end of May to September. If I apply for the TRS IUF for her, will it affect her maternity UIF application?
A maternity application. Let me just see.
It's I posted it on the chat. So there's an employee that's going on maternity leave now, in a couple of weeks until September. But if they're applying for that tertiary employment relief scheme UIF at the moment, will it affect her kind of general UIF application, maternity leave application overall?
I'll be honest, I'll have to look at that.
Okay,
Mary.
it is quite specific, so we
I
can.
don't want to speak from the hip and then the wrong advice is given. So I'm more than willing to just have a look after the session privately, directly with the listener.
Okay, great. Thank you. And then Lauren Willens has got a question. Let me just unmute her. Sorry, Lauren, I'm just going to find you quickly. Okay, Lauren, feel free to ask your question.
Yeah, thanks very much. I just had a question. I think this is up for interpretation, but I just wanted to check if I'm missing anything. One of the points mentioned in the new regulations is that they demand that companies must ensure that employees who can work from home do work from home. So we were just wondering if there's any legal requirement or penalty, because we've got staff that can work from home, our whole business can because we're a tech company. But if we choose to open the office and it's obviously safe according to the new regulations, I mean, is there anything, is that up for interpretation? Do we choose that? Or is there somehow that they've come up to say, well, you can work from home, why are you working from the office?
No, so are you saying from the employer side, you want to force them to come back to the office?
Well, we don't want to force them, but there might be certain people they can work from home, but they might want to come into the office or whatever reason. But the law, everything that you read, it always says if you can work from home, work from home. So we're just trying to juggle that.
This is like everyone's question.
Yeah.
So everybody sees like, no, this is a lot better. It's more efficient to work from home from home than going into an office. But obviously, I mean, from an employer's perspective, if you put in all the safety measures and your requirement is that the staff needs to come to work, and you put in all your safety and you do whatever you need to, I can't see why you can't tell your staff to come back. And when your business requires the staff to come back to the office.
Yeah, so it's not like government's going to say, well, actually, you should be working from home. There's nothing that's just up to interpretation. We decide.
No, not that I would that I know of, Lauren. No, but
awesome.
I mean, if you as a business decide, and I know your technical, the techies are all you're part of the open at this point. You can work. So your staff can go to an office and work. So there's nothing that I can see that would stop that.
Okay, awesome. Thank you.
Okay, Lauren.
Great. Thank you so much, everybody. And thanks, Lauren, for that last question. Danelle, thank you very much. I mean, obviously, from the legal standpoint, there are a lot of very specific cases, but I think that your presentation gave us a great overview. I love the fact that you said we should do a legal health check with our various policies and contracts in our businesses. So just to everybody, we will be sharing the deck and the recording. Please also feel free to contact us if you have further questions. We can also introduce you to Danelle for specific cases. Thank you once again for your time over this lunchtime. And Danelle, once again, a very, very big thank you to you from the Thinkroom team for doing this wonderful webinar for us on quite a sensitive topic over this challenging time.
Thanks, Marianne. Thanks for everyone, and good luck to all the businesses. I know it's a difficult period, but we have to focus on the positive and see how we can grow our businesses and move past COVID and see how we can grow going forward.
Great. Thank you so much, everybody. Bye-bye.